Hello, everybody. Hi, everyone. How are you, Joey Bag of Donuts? Sir Philip, my dear friend. Nana Laura. Hello, Patrick B. Hi, Colette McCoy. Thank you. I've got a half hour to go before it's officially the 4th of July, but we will get there. Hi, Michelle Moreland, my sweet love. Brian Buggs. Oh my gosh, I feel like I haven't seen you in forever. It has been so long. I have missed you. I'm so happy you're here, buddy. Thank you for making it, Chancellor. Hi, Barbie. Great to see you, sweetie. Chinny. Hi, Chinny. So happy you're here. And there's the beautiful C-Rex. Hi, sweetie pie. Look at this. Look at that cat right there. He made 6 months, so that means he has the Ava badge. Hi, Kiki Blue. Oh, we have missed you. I swear we have. Just don't make it so long again, and we'll forgive you. All right, guys. So, I'm going to apologize in advance for the audio on like the second clip-ish, the second judge. Oh, Patrick B. That makes me so happy to hear you say that. I want everyone to feel welcome. So on the second judge, the audio is terrible. And there's nothing I could do about it. But the judge is funny, and he's cranky. And you know I love that. That's like my favorite thing, cranky old men. They make my day. So, we're going to start this off in Kansas City, Kansas. One of C-Rex's favorite judges, I think. No, it's one of her favorite places, but I think it's the other judge. Shoot. But, or, you know, in the words of that one defendant, dang it. Hey, Shane. So happy you're here, buddy. So, yeah. All right, let's just get into it because I could talk forever and just screw it up the whole time. Oh, actually, before I do that, y'all remember Mickey Mouse? So today, well, technically yesterday, was that Marsden hearing that he set up. So I did happen to catch it. The only problem is those are closed hearings. So we only get to see him come in and, you know, just futz with his hair and the blinds and then, you know, demand that that everyone's going to clear the courtroom, because he calls the shots. So it's only a couple minutes. I'll make sure to put a link in the description. He was not fully soft, but very soft-sit-ish. He has sued everybody. He has filed every motion. They can't keep up with him. I will make sure to put the link in the description. But we're gonna go with him first, just because it's such a quick clip.
They haven't answered anything yet, so. Getting ready for a fun procedure, huh?
What's that?
Getting ready to go out for a fun procedure, or is that just water?
Oh, no, that's just water.
Oh, okay.
Yeah, I didn't know how long I was gonna be standing out there. That's true.
You gotta make himself look good,
What do you think about your case with Stanislaw County?
Yeah.
Okay. Figure you probably know more about it. You know how to unmute that and all that?
You want this open? When,
I don't, but if you want it open, you can.
no, well, a part of this, is gonna require the courtroom be clear, so that means you too. So you gotta watch from like the window.
When it's time, then that's fine.
Yeah, so that's what I'm saying, you want these to be like.
Yeah, when it's time, when you open it, I'll say.
I was typing the reply, but now I might as well say it. So the first hearing, he had loops on his head from those braids. And it really did resemble Mickey Mouse ears. Yeah. So because it was a closed hearing, we unfortunately don't get to see it beyond that. But that was the update. And we did get to see. Everybody's got the same reaction. You're so vain. No. He really was. He was so like all up in himself. Like just the first hearing, like that one, you couldn't tell nearly as much. I mean, he just primped himself, but yeah. Stanzalot, or Stanzalos. Somebody sent me the pronunciation as Stan is lost. And I still can't even say it correctly. Stan's lost. Something like that. Hello, Sean. Good to see you, love. Okay, so now that we had that fun, the judge said it in the last hearing that he was entitled to a closed hearing. So I don't know if that's specific to Marsden hearings that they do that, but the judge did say that it was going to be a closed hearing. I wasn't sure that I would get anything, and it was like an 8-hour docket, and I went through each case to look for him or to hear if, because it was a closed hearing, I didn't know if maybe, it would just be the prosecutor speaking or what the deal was. So I went through every case, and yeah, that was all I got. That's kind of why it was a little later tonight. It's Marsden. We can take a really quick field trip. Really quick one. So oh, Michelle Moreland, thank you so much. I love you. That is the sweetest thing. Thank you. Hey, Salty Buddha, honey. Okay, guys, we're going to go on just a really quick field trip to explain this. So, a Marsden motion is a request by a criminal defendant to fire his or her appointed public defender and acquire new representation. The defendant must show that the appointed attorney is not providing adequate representation or the attorney has a conflict with the defendant. So his big claim was that the public defender that they wanted to give him was incompetent and he wanted to represent himself. But they were hesitant on allowing that because of all of the chaos that he had already created just in the numerous motions that he had filed, lawsuits against every judge and every prosecutor and every this, that, and the other. So, yeah. I don't know. She needs a good jailhouse lawyer, apparently. Yeah. Yeah, that's the rub of it. Yeah. Stan is lost. Thank you. I just can't do it. I try. It's just going to be one of those words. All right, now that we've got that out of the way.
Ms. Robinson.
Thank you. Good afternoon, Ms. Robinson. I'm Judge Schultz. I'm one of the municipal court judges. You've been given an OR bond on your city cases, but we wanted to make sure we talked to you while you were still in custody on the county cases. It looks like you have a variety of traffic. I'm going to just go over them very briefly. Looks like you were charged with having a defective headlamp and no proof of insurance. Those were alleged to have occurred September 29th of 2020 in the area of 38th and Oakland. Defective tail lamp, not having a driver's license, no proof of insurance, and a defective headlamp. Those were alleged to have occurred January 5th of 2021 in the area of 10th and Walker. Defective headlamp, that was alleged to have occurred April 7th of 2022 in the area of 47th and Lafayette. Violating a traffic control signal, no proof of insurance, and driving while suspended. Those were alleged to have occurred November 9th of 2022 in the area of North 78th and Parallel Parkway. Driving while suspended and failing to signal before a turn. Those were alleged to have occurred April 22nd of 2023 in the area of 11325 Lafayette Avenue. Do you know what's going on with your driving privileges?
Some of them I couldn't go to court because the city was shut down when the COVID was out. They wouldn't let us come to court. So that's the reason why some of them weren't taken care of. And I tried to get my license back, but they didn't tell me how to get them back a long time ago.
Okay, give me 1 second. I'm gonna try to look it up. I tried to look somebody else's up earlier today and it didn't work, but.
And I
sometimes
spent, sorry to cut you off. I spent 3 days in jail last year for $100 warrant that was here for Kansas. And after I spent the 3 days, Parallel Village came and got me for 4 days. And they said my stuff was taken care of for me spending the time in jail. They said they wasn't gonna hold me no more than 3 days because my warrant was only $100.
That was quite a while ago. We are now in 2024. COVID was, 2020 and 2021 was, the big era of that. What have you done since then?
For Kansas.
It does look like you were booked April, maybe 23rd or 24th in 2023. We granted you just an OR bond right away, and you were supposed to appear in court May 23rd of 2023. But
They didn't
looks
explain
like
that to me.
maybe
They said them days was taken care of. That's the reason why I didn't come.
it doesn't look like she even really saw you. Give me 1 second. Okay. Do you know if your license is under Robinson or Abson, or if it's hyphenated?
It's hyphenated.
Okay.
Well, they was hyphenated.
Okay, that's what it was under. Okay, give me 1 second to see. Let's see if this works. Give me 1 minute. No, it wouldn't do it for this one either. This really, when this system works that the state has, it is great. When it doesn't, it's very frustrating.
Mm.
Okay, so it looks like at one point you were supposed to meet with Kansas Legal Services. So what we're gonna do, because Kansas Legal Services was trying to help you get your license reinstated, you've already been given an OR on the city stuff. We're just gonna continue this into August to try to give you an opportunity to meet up with Kansas Legal Services. We're gonna put this on August 13th at 1 p.m. You'll need to come to City Hall if you've been released August 13th at 1 p.m. When we finish this docket, we'll send over the paperwork to the jail showing that. They'll put a copy in your property, so if you get released, you'll have a copy showing that you need to appear in person August 13th at 1 p.m. Okay?
So what was the attorney doing then? Because I had an attorney. His name was Mike somebody over on 7th Street. He supposed to took care of all that. I didn't have to go to court or none of that.
Yeah, you actually do have to come to court to speak to Kansas Legal Services.
No, I'm saying I didn't have to go to court. When he was going to court for me, he said I didn't have to.
Well, I don't show any other attorney other than Kansas Legal Services, and you do have to appear to talk to them so that they can try to arrange some sort of a diversion agreement or something for you. So you'll need to appear August 13th at 1 p.m.
That's fine.
All right, thank you. You can give the headphones back to Mr. Doyle.
So do I come back to court between that time?
You'll come back to court August 13th.
Yeah, I remember August the 13th.
That's when you'll come back to court.
Okay.
I'm sorry about the voice. I could do nothing about that. And just as I could do nothing about the audio on this next one, but at least the judge's voice is not that.
Jail, I just need to take care of Mr. Soto first, 24380. Mr. Day, I will not be able to arraign Mr. Soto. Apparently, what's alleged in there involves, destruction to property belonging to my family. So, I will not be able to arraign him, nor will I be able to have his pre-exam conference on July 9th at 10 a.m. or his preliminary exam on July 23, since the case was assigned to me. So given that, I will have to disqualify on Mr. Soto's case, I will attempt to find a judge, or I'll send it back to criminal division so a judge can hopefully arraign him today. I do note that there is an interim bond that was set by the signing judge on that. Thank you.
Understood, Judge.
Destroying the judge's family property is probably a good way to ensure you're going to be in jail for a minute.
The matter of People versus Mar, 2513139B, 2023863B, 2513087A. She is. Yeah, that's right. Appearances for the record.
Ethan Day on behalf of Mr. Marr, Your Honor, we'd waive the formal reading.
All right. Let's see. Bench warrant, failed to respond to a 10-day letter. How long has he been in jail?
Mr. Marr,
Overnight?
how long you been in custody for, Mr. Marr?
Maybe 9 hours.
Yeah, whatever. You owe, $225 to Judge Clark on that misdemeanor. Why aren't you taking care of it?
I did not get any mail at my address. I don't have a mailbox. I have a PO box.
Bench warrants. Why do you just keep ignoring the courts? Come on.
Well, huh?
What have you done to get your license?
Oh, I tried to go fill out a packet and I tried to give it back to the judge, but he told me that I was playing around, which I wasn't. I was filling out the packet.
You're wasting air in jail. You know, a judge doesn't issue a license. It's Secretary of State.
Yeah,
Your driving record is enough that you should have had enough contact with,
The judge told me.
that it's the Secretary of State that does all that. Recall bench warrant. What are you gonna pay?
Judge Mr. Marr informed me that he could pay everything on Monday when he gets paid at Hooters. He's been there for a long time. He's employed full time. He can pay everything on Monday.
All right. Well, your civil infractions, since you've been in custody, those were credited time served, okay? Suspended it since you got to smell the wonderful inside of that jail. Now, on the misdemeanor ones, you're gonna have to pay that. So, time to pay will be 1 week. You gonna take care of it?
Of course.
All right. Just put your license so you don't run into local law enforcement. No, have a good day. Be well.
In fact, I sent.
So, in that one short clip, we have the judge saying, whatever, when the defendant says that he's been in custody for 6 to 9 hours. We have the judge saying, you're wasting air at the jail. And then, oh gosh, what was the last one? You're being released since you got to smell the inside of that wonderful jail. I told you I love cranky old men. Okay, now this one, this is going to be the majority of our docket is this judge here, and this is at Otsego County, Michigan, and this is the thumbnail guy, so enjoy this.
Specifically to your office, 2 copies of some of the motions, because in my system it was not showing up in the sent file indicating that it had been received. So I wound up sending double copies, perhaps, to the court. I did receive finally this morning in my system an indication that they actually had been received by your office. The delay that I will take full responsibility for, however, Your Honor, is we have a number of matters that are scheduled this week. The Phillips matter, I confused with another case that I also filed a brief on that I'm now finding out actually is now scheduled for Friday. I thought it was before this one, so I did them in the wrong order, and that delayed because of course, we only have 2 attorneys in our office now. My being able to finish the Phillips matter, when I saw that it was actually done, I wanted to make sure I got copies out to the court. Thank you.
All right, thank you. So here's how the court reacts to all of that information. I certainly understand and sympathize with you, Ms. Murphy, that when you receive a response from a prosecutor on the morning of hearing, you're not going to be given the opportunity to examine and potentially respond to any or all of the cases that have been cited. And I also am in the same position. While I understand what you've offered in terms of your explanation, Mr. Rolla, I don't really excuse the lateness of the filing. In other words, I've read what you supplied. I too have not had the opportunity to read each and every case that you cited because of the late nature of the time that I got it. But I also am in this unique beneficial situation. This was and is my case. I've been handling this matter, have independent recollection of it from the time of the hearing, both the sentencing and the plea hearing, because both were fairly different than typical hearings, because there were specific questions by Mr. Phillips about the maximum penalties, for example, with regard to the possession of intent to deliver methamphetamine. I had to have some breaks, which I don't often have to do, to let Mr. Phillips talk with his attorney at the time, Mr. Gilo. And I also had to then answer several different questions and then reconsider my own exercise of discretion at sentencing, which not only doesn't happen often, it doesn't come up by way of request often. In this case, I'm aware of all of that background. And so while I always accept and then take into account attorney's arguments, I'm also not always in need of them. I certainly was in need of hearing the defense arguments on the motion to set aside or to allow the motion to withdraw plea and or correct an invalid sentence. And those are helpful in context to me, but overall, I'm not in need of the response of the prosecutor. So to the extent there's any claim of error or any claim of reliance that the defense thinks I'm relying upon the prosecutor's arguments, I'm not. I'm ready to make my determination because I know the background of this case. And so I'm going to do that, and I'm going to do so even though the attorneys may want to offer oral argument without the benefit of oral argument. Otherwise, in other words, I'm exercising my discretion under 2.119E3 in this motion to dispense with oral argument. Again, I'm doing that because I have the discretion to, and I'm fully capable of understanding what's been presented in this case and ruling upon it without further oral argument, especially given the nature of the brief, the length of the brief, the complexity of the brief, and how well it was written by defense. Again, I say that respectfully, it's a helpful brief to me because it pinpoints all of the issues that the defense is arguing. Because of that, and because I did receive the people's response and have a chance to review it, I'm not in need of oral argument. So I'm going to start first with the defendant's motion to withdraw the plea. As I understand it, there's 3 primary attacks. First, they claim that the plea was not knowing and voluntary, and secondarily, as a result of the plea not being knowing and voluntary, that I should have allowed the defendant to withdraw his plea, which is what he asked for at the start of the sentencing hearing. And then secondarily, or I guess third, an allegation of ineffective assistance of counsel for not filing a motion to suppress related to the traffic stop at issue. So a lot of those things then have to be covered. The way that the court finds it most beneficial is to kind of put in context all of this. Again, I was there at the plea hearing, so was Mr. Phillips. At least as far as my recollection goes, it was not Mr. Rolla, it certainly wasn't Ms. Murphy, it was Mr. Gilo and Mr. Fenton, the prior prosecuting attorney for the people. But in any event, we have a transcript, and that's beneficial. It speaks for itself. But certain portions of that transcript are helpful to the court's analysis when it gets to the claim of a claim that there was no voluntary or knowing plea. And so first I start with the standpoint that I already referenced. When I first called the case in the morning of whatever the date was of the hearing for the jury status conference and plea, Mr. Phillips advised me that he had not been able to be in contact with Mr. Gilo. And so I immediately stopped the proceedings, had Mr. Gilo respond to it, and then ultimately offered to have Mr. Gilo meet with Mr. Phillips in the jail, and then I called the matter later in my afternoon. I don't always have the ability to do that particular docket I did. So I had Mr. Gilo volunteered, and he did go down and see Mr. Phillips, talk to Mr. Phillips, and then I recalled the case later in the afternoon. Immediately upon retaking the bench and calling the case, I asked Mr. Phillips, and this was at page 7 of the transcript of the plea hearing, I said, thank you. So Mr. Phillips, in between the time we called this case in the morning and now, have you had sufficient time to discuss this matter with your attorney? And Mr. Phillips responded, I have. Later, the attorneys put forth the relevant plea agreement on the court record, and I asked, this is on page 8 of the plea transcript. I stated, all right, Mr. Phillips, did you hear all of those terms? Answer from Mr. Phillips, yes, I did, Your Honor. The court, is that how you want to proceed, is by entering guilty pleas under those terms? Mr. Phillips answered, yes, it is. Page 9, I started going through the specific plea agreements. The court at line 11 of page 9 indicated that in the second file, 23-6587, in that file, you're charged with delivery or manufacture of methamphetamine in count 1 and in count 2 with operating with license suspended, revoked, or denied. Are you aware of that? Then Mr. Phillips answered, did you say delivery intent or possession with intent to delivery or delivery? The court's answer was, starting at line 17, yeah. And to the court, there's no difference, but I understand there's a significant distinction probably to you. Yes, it's charged as possession with intent to deliver the controlled substance methamphetamine in count 1. Are you aware of that? Answer, yes. Question from the court. And when I say it doesn't matter to me, it's because the punishment is the same, whether it's a completed delivery or whether it's possession with intent to deliver. The circumstances obviously are different, but the penalty is the same. But in any event, under the 6587 case number, you're offering to plead guilty to count 1 with possession with intent to deliver methamphetamine and count 2 operating while license suspended, revoked, or denied. Are you aware of that? Answer, yes, I am. Question from the court. And then the benefit of that plea agreement is that the prosecutor in that file would dismiss everything else that's been charged against you. Are you aware of that? Answer, yes, I am. Next question from the court. Possession with intent to deliver methamphetamine is a felony offense. The maximum punishment for that felony offense is up to 20 years in the state prison system and or a fine of up to $25,000. Are you aware of that? Answer, I am now, Your Honor. I thought it was a 15-year felony. I thought it was lesser than delivery. Question or statement from the court. It's not. It's the same exact penalty. It's a 20-year maximum, whether it's a completed delivery or intent to possess or intent to possession with intent to deliver. Are you now aware of that? Answer, I am now aware. Question from the court. And do you still want to go forward with the plea agreement? Answer, I would like to talk to my family about it, to be honest. I know it's a good plea. I just don't. Could you explain to me a little bit about how it's going to affect my scoring agreement? Is it the same as if I pled to a delivery? Question from the court. So the delivery, answer from Mr. Phillips, like, am I still going to, the court then states, a delivery offense and a possession with intent to deliver offense are on the same scoring grid. The guidelines likely would be identical. The guidelines, as you know, Mr. Phillips, are fact specific. So the court can't tell you what the guidelines will be until I examine the facts, which I'll only get once I have a pre-sentence investigative report. The benefit of the plea agreement, though, is going to be the same, which is if you plead guilty to possession with intent to deliver, the prosecutor is going to dismiss the second or subsequent offense notice, which could have the effect of doubling guidelines range as well as the maximum, doubling the maximum punishment. The prosecutor is also going to dismiss the habitual fourth, which, of course, as you know, carries with it a life potential maximum in prison. So the offense characteristics, the maximum punishment is the same, again, between possessed with intent to deliver and the delivery itself. Does that answer your question? Answer at line 25, page 11, it does. Further on, discussion between the defendant and the court occurred at page 15, starting at line 11. I also was going over the fact that Mr. Phillips would not necessarily be giving up his right to trials and all of the other trial rights that he would give up. Next question from the court was outside of the plea agreement. That's been discussed on the open court record today. Has anyone promised you anything else to get you to plead guilty? Answer from Mr. Phillips, no, they haven't. Question, has anyone threatened you in any way to make you feel like you have to plead guilty? Answer, no. Are you pleading guilty freely and voluntarily? Answer, I am. Question, and is it your choice to plead guilty? Answer, it is. Then I started in reverse order with the offenses, and to the next page on page 16, starting at line 12, I referenced the date of April 21st of 2023 and asked Mr. Phillips, does that date sound accurate? Answer, line 13, yes, it does. Question from the court on April 21st of 2023, were you again here in Otsego County? Answer, yes, I was. Question, on that date, did you possess the controlled substance methamphetamine? Answer, yes, I did. Question, while you possessed it, did you have in your mind the intent to deliver the substance to someone else? Answer, yes, I did. And question, and you're not claiming that you had any lawful authority to deliver the substance, are you? Answer, no.
He does have to go through the entire transcripts of the previous case history. I'm sorry. Just pretend it's an Audible book.
Later, the court, of course, accepted the plea. I made a specific finding, as I'm required to do under the law, but which I did in this case, that the plea was knowing, voluntary, and accurately given, and that there was a sufficient factual basis to accept the court's finding. The attorneys expressly agreed on the record, including Mr. Gilo, as did Mr. Fenton, the attorney who was present in the courtroom at the time. Both attorneys agreed that there was an adequate factual basis. Both attorneys agreed that there was no promise of stress or inducements other than those disclosed on the record, and both attorneys agreed the court comply with the court order regarding taking the pleas. So taking of those items from the plea hearing and going back through the claims that are made in the brief in support of the motion to withdraw the plea, the court notes that it's clear that Mr. Phillips, as he did at the time of sentencing, repeats again his allegation here that his plea was unknowing because he didn't understand the maximum and he didn't understand what he was going to be sentenced to. But as the court covered at the sentencing hearing with Mr. Phillips, his guidelines range is not something that was part of the plea agreement. And it had nothing to do with whether or not he understood whether his plea was knowing and voluntary. I went over the explicit terms of the plea with Mr. Phillips on numerous occasions when he expressed any confusion whatsoever. For example, his confusion that he told me he thought the possession with intent to deliver methamphetamine was a 15-year max, not a 20. I not only clarified with him, I then made sure that he still wanted to go forward after I clarified with him. He told me he did. I answered the questions he has. It was clear to me at the time of the plea, and even clearer now after this sufficient review, that Mr. Phillips fully understood the nature of the plea agreement and its benefit, particularly dismissal of the second or subsequent offense notice and the habitual fourth, for his pleas to the offenses that I allowed him to lay a factual basis, for which he did lay a factual basis, for which the attorneys agreed there was a factual basis and a lack of any promises, threats, or inducements, and for which I accepted all of those pleas. So while it's clear that Mr. Phillips now second guesses and claims that he did not understand the nature of the plea agreement, I don't find that argument to be compelling at all, especially in light of clarity in the plea transcript and in my memory of it, independent of the transcript itself. The requirement is then, if the defendant, Mr. Phillips, wanted to withdraw a plea, which is what he asked at the time of sentencing, he would have to establish a basis for it. To the extent, Ms. Murphy, you're accurate that I'm relying upon a version of the court rule that applied to a plea before it was accepted or after sentencing, the distinction is meaningless to the court in this way. When a defendant makes a request to withdraw the plea, under whatever standard, it's the burden of the defense to demonstrate that there's a proper basis for withdrawal. Here, the proper basis that Mr. Phillips asserted was that he didn't understand what his plea would be. Again, a clear review of the transcript shows that Mr. Phillips is wrong in that assertion. He understood because he told me he understood, and he did so while being sworn in under oath. To the extent that there's a claim that he didn't understand what the nature of his sentence is, again, the prosecutor cited case law, and while I recognize that you have told me, Ms. Murphy, already, you haven't had a full opportunity to review and then address or respond to those, the case law is what the case law is. It's very clear before the prosecutor filed that response that a defendant's dissatisfaction with the guidelines range, unless the guidelines range is part of the plea, or defendant's dissatisfaction with the court's chosen sentence, unless that chosen sentence was part of the plea agreement, is not a basis to set aside a plea under Michigan law. The sentencing phase is different than the plea phase. Defendants know that. And I also referenced at the time of the sentencing hearing that Mr. Phillips was not just a defendant. Mr. Phillips was a defendant who has been in front of me on various plea-based proceedings and other matters for years. I've always told Mr. Phillips at different sentencing hearings that I thought he appeared to be intelligent, well-spoken. I even granted relief to him in a prior case that I referenced at the sentencing hearing, unique relief in that where the guidelines called for a prison sentence. Mr. Phillips told me he was going to get the heck out of Dodge, is basically what he told me. And he's never going to be back in this area. And if he's not in this area, he's not going to be able to be around the same crowd. And he's not going to commit the same types of crimes again. I listened to him. I found him to be intelligent and thoughtful. I thought that he had a good plan for the future. I followed his recommendation over quite a stern objection by the prosecutor, who was asking and begging me to sentence Mr. Phillips to prison. I didn't do that. I sentenced him essentially to time served and allowed him to move out of the state, which he did. I bring up that historical example now, just like I did at sentencing, because it's an insight that I have into Mr. Phillips that I think is probably lost on the record, which will be created for the Court of Appeals without an expansion. Meaning I have personal involvement with Mr. Phillips. If he expressed confusion, I would have known that he was confused. If there was any confusion, I would not have proceeded to accept the plea from him. I know that he had no confusion because he expressed it to me. He had expressed it to me before. He was consistent in all of those times. So again, that's a factor that I think weighs substantially in favor of my finding previously and adopting it again today, that his plea was knowing and voluntary. Because Mr. Phillips knew that he expressed confusion, and if he did, I would do my level best to clarify it. So even to the extent the court was relying upon some erroneous understanding that there was a different standard, that I had to show that there was an error in the plea proceedings versus in the interest of justice, under either circumstance, there was no interest of justice to withdraw a plea, and there was no defect in plea proceedings. So under either circumstance, there wasn't any basis, any proper legal basis for the court to allow a withdrawal of plea, and therefore it's not appropriate for the court now to allow that, or that he should be able to, after his sentence, now withdraw the plea. When I turn to the issue regarding the stop, one of the arguments is that there was no proper stop in file 65387, which is the subject of this possession intent to deliver. The police report, or at least an excerpt from it, was provided by defense counsel, which indicates under traffic stop that on 4/21 of 23 at approximately 01:45 hours, I observed a black and colored Jeep traveling westbound on West Main Street. I got behind the vehicle as it was turning north on North Ohio Avenue, and as I drove behind the vehicle, I could not see a license plate attached. I initiated my emergency lights to signal for a traffic stop near West Joe Street. As I hit the vehicle with my spotlight, I could see there was a paper tag in the window that was not visible due to the tent. The paper tag read 803362D. Vehicle pulled on, then I contacted the driver. The question, of course, in a traffic stop situation is whether or not police had a reasonable belief that the defendant was committing a traffic violation. Here, based upon that relevant portion of the excerpt of the police report, it appears clear to the court that the police had a reasonable belief that there was a violation of traffic laws. That their belief may have ultimately been erroneous is not even the question. The question is, at the inception of a traffic stop, was there a reasonable belief by the police that there was a violation? The police report excerpt in the defendant's brief establishes exactly that there was that reasonable suspicion. That is, that not until the officer hit the vehicle with his spotlight could he see even paper tag in the window, but that the tag in the window was not visible due to the tent. In other words, the tent that Mr. Phillips had on his window prohibited that tag from being visible. It appears clearly that the police, at least to the court, had reasonable suspicion and thus could have effectuated a valid traffic stop. Once they make the stop, of course, anything else that happens, as long as the stop is not erroneous at its inception, is okay for the court to consider. In light of the standard, the defendant would bear the burden of demonstrating that the police did not have a proper basis, or even if stated another way, once a proper motion were filed, that the prosecutor could meet its burden of demonstrating the lawfulness of a stop. To the court, there's no reasonable basis to believe that a motion, even if it was filed, would have been successful. Because again, it appears clear to the court that the officers were going to indicate the same thing indicated in the police report. We had a reason to stop because the tent prohibited us from being able to see the tag. If you can't see the tag, that's not supplying the tag in a legible manner as required under the driving statutes. And so, in my view, there is no possibility that there is ineffective assistance where an attorney's choice not to file a motion which would be denied was what ended up happening here. It's also worth noting as well that, as commented by the defense counsel in the brief, when defense counsel's actions are a matter of trial strategy, the court normally will not deem them to be constitutionally ineffective. And this is something that the court is looking at, obviously absent any testimony or evidentiary hearing, which was requested from Mr. Gilo. But it would appear to this court to be an abundantly reasonable trial strategy in a case where Mr. Phillips was charged across 3 felony files with a multitude of life offenses to seek what the defendant did seek, defense counsel did seek in this case, which is a global plea resolution. In other words, dismissal of many of the significant charges, enhancements, second or subsequent and habitual forward, and the attempt to resolve the case with convictions. That's exactly what Mr. Gilo did here. So while I can't say that Mr. Gilo certainly had a trial strategy of not trying to spoil the case's plea agreement by having a global plea agreement, that would seem to be entirely consistent with what I did as a defense attorney before I was a judge, what I see defense attorneys doing all the time, which is trying to have all of the cases treated together. And I say that because if Mr. Gilo would have filed a motion to suppress in one particular case, that easily could have, and I have seen it happen in this particular county with Mr. Rolla as prosecutor, where a defense attorney's decision to make a effort to have a matter suppressed affects negatively the potential of having a global plea offer in all of his files. In other words,
Judge, may I interrupt you for one moment? Could you mute Mr. Phillips and Mr. Rolla? There's noise coming from people moving around, and it's difficult for me to hear you, and I'm afraid that the recording will be unclear. I'm so sorry to interrupt.
No, I appreciate that. I heard some, and I should have acted on my own. I just muted Mr. Phillips, and it sounds like that's where the sound was coming from, but let me know if you hear it further, because you're right, we need to have a good, clear transcription of this hearing as well later. But in any event, again, I have seen from Mr. Rolla at times where if a defense attorney who has multiple files with the same defendant challenges the propriety of a stop in one file, Mr. Rolla's reaction is, well, then I'm not going to offer the same plea agreement in another file. I'm not saying that I know that to be the case in this case. I am saying that prosecutors generally act similarly across files. I am saying that when I was a prosecutor trying cases against Mr. Rolla, I had to account for those same exact things, which is where if I strategically chose to try to file a motion to challenge a stop in one file, he may react negatively to that in circumstances involving the other files. What I'm saying is that from that information that I have from dealing with this particular prosecutor, I know that that would be a reasonable trial strategy. I don't know whether or not that's what Mr. Gilo did, but I do know that across a multitude of files, he secured what amounted to be a very fair plea offer, which Mr. Phillips expressed he knew was a very fair plea offer, dismissal of all of the habituals and a second or subsequent offense notice, although the penalty was certainly more than what Mr. Phillips wanted. So in hindsight, I don't find that there's any reasonable basis to accept or expect that if Mr. Gilo would have filed a motion to suppress, A, that would have been granted, or B, that would have ultimately assisted in the defendant's overall defense. And so I don't find that there's a basis that there would be any likelihood of changed outcomes, and I don't find that the Strickland test for ineffective assistance can be met. So the motion to withdraw the plea, although well argued, is denied. I find that Mr. Phillips clearly knew what he was getting into when he entered the plea. He did so with both eyes open, and I would not have allowed him to enter the plea if he didn't do so and convince me that he did so knowingly at the time of the plea. So the defendant's motion to withdraw the plea is denied for the reasons stated. Mr. Rolla, what I'd like you to do is prepare an order that just states, for the reasons stated, the motion to withdraw the plea is denied. Can you prepare that?
Yes, I will. Thank you, Your Honor.
Do you have any questions regarding the court's order regarding the motion to withdraw a plea, Mr. Rolla?
No, Your Honor. Thank you.
Do you, Ms. Murphy?
No, Your Honor, thank you.
Then I'm turning to the motion to correct invalid sentence. Again, I don't want to take the attorney's time. That's not my focus of doing this, but I have taken a lot of time to go through different portions of the sentencing transcript. And so I incorporate the findings that I made in the statements that were already in all of the plea hearing and all of the sentencing hearing, but I am going to take some time to go through some, I think, important terms related to the sentencing hearing as well. Because again, I've read the defendant appellant's motion to correct invalid sentences, and I understand the claims. Primarily, the claim is that there was not accurate information upon which Mr. Phillips was sentenced, and if he's sentenced based on inaccurate information, then he's entitled to have his plea withdrawn or to have a new sentencing. And the other countervailing argument or counter argument that if his attorney didn't assist him in getting the information, then it's also ineffective assistance. But again, I review this case from the background standpoint that this was somewhat unusual for me. It was not a typical sentencing hearing. Mr. Phillips wasn't a typical sentencing defendant for all the reasons I indicated at the time of the sentencing. So this case was unique. It stuck out to me at the time. It still does. Now I've had also the additional benefit of reviewing all sentencing transcripts. So when I started the sentencing hearing on page 4 of the sentencing transcript, I indicated, Mr. Phillips, we're here for a sentencing hearing today. Have you had enough time to go over the PSI with Mr. Gilo? And his answer was, yes, Your Honor. At page 6, I then heard from Mr. Gilo. I said, thank you, Mr. Gilo. Mr. Phillips, was there anything that you want to tell me before I impose sentence today? And some brief background is in order. The attorneys know this, but the record always benefits from clarity. At every sentencing hearing, there's an order of business. The order of business first starts with identification of the parties and the attorneys. Then I ask whether or not the defendant himself or herself has had enough time to review the body of the PSI. If there's any answer other than yes, I take a break and have the attorney and the defendant meet. Once I'm satisfied that the defendant does not need more time to meet, then I go over any challenges to the body of the report, first with the defense, then with the prosecutor. Then I go over whether there's any objections or challenges to the guideline scoring. I did that in this case. Then I hear allocution in this order. This is personal preference by me, and I know other judges do it different. I hear allocution first from any victim. This was not a victim crime. Then I hear allocution from Mr. Rolla. Then I hear allocution from, or Mr. Fenton in this case. Then I hear allocution from the defense attorney, and then last I hear from the defendant. I choose to do that on purpose because I like to last hear from the defendant, not the attorneys. Because often, in my view, it's the defendant's statements that have more meaning to me than the attorney's. That's not to say that I don't listen to the attorney's comments. It's just that I've always found more compelling a defendant's words and version of the events than I have an attorney's explanation of it. In any event, I then asked Mr. Phillips if he had anything that he wanted to tell me. Of course, my belief was we're at a sentencing hearing. I'm asking him if he has anything to tell me about the sentencing, about the case, and about anything that relates to those things. That's when Mr. Phillips at page 6, line 20 says, "Yes, Your Honor, I came here with the intention of withdrawing my plea. I feel like I've been very improperly represented." I would first note that as to that point, I feel like I've been very improperly represented. It appeared to the court at the time and now to be relatively contrary to what Mr. Phillips had told me a few pages earlier in the transcript, that he had enough time to talk to his attorney before and go over the PSI with him. Again, that would be the time, in my estimation, that he would bring up those issues of improper representation if he thought he had them, is when I asked him if he had enough time to go over the PSI with Mr. Gilo. But nonetheless, I continued on, and I heard from Mr. Phillips why he expressed that he didn't have enough time with Mr. Gilo. He expressed that he wasn't aware of what he was pleading to and what his guidelines may have been. And I finally heard from him and then indicated on page 7, "Thank you, Mr. Phillips. We're not going to be delaying this case any further. Today is the date for sentencing. The law is quite clear on your ability or lack of ability to withdraw your plea." I then went through all of the different background information, my view and my ultimate finding that there was no lack of understanding. What I told Mr. Phillips on page 9, there was no lack of understanding what he was pleading to, what the penalties were and what the benefits were. And I said the benefits were with your 15th and 16th felony, you're convicted here with no habitual. I went through a lot of other analysis, as I tend to do. Sometimes I'm long-winded, which is not always a good thing. But I went through and intended to and did sentence Mr. Phillips. So I told him I'm going to impose a 9-year minimum term, which is 108 months. That's not the maximum of the guidelines, but it's high and it's reflective of the high nature of these events and the fact that you continue to do the same things over and over again. I noted at that time that it was clear to me Mr. Phillips was raising his hand. He wanted to be heard. I then said to him, "Did you have something you wanted to say, Mr. Phillips?" Mr. Phillips responded, "Well, I did. I wanted to speak to you before you sentenced me. Besides saying, all I got to do is come here and say I wanted to withdraw my plea." So I initially exercised my discretion. I started to cut Mr. Phillips off because I wasn't going to allow him to continue to be heard. But he continued to explain, and in my view, a respectful way, because if he wasn't respectful, I would have just cut him off altogether. But he was respectful in telling me that he didn't think I was going to sentence him. He wanted to talk about his ability to withdraw his plea, and I went right into sentencing after that. So I did then reconsider my discretion, and I told him that it makes sense to me, in essence, that he would want to be heard. So I let him be heard. I let him be heard in totality, without interruption. At one point in an event, he viewed it as me interrupting, and he said, "Please don't stop me. There's no doubt in my mind I can do this." And I tried, and that's what I wanted to do. In other words, he wanted to allocute. He wanted to express his view of the case. I stopped what was my automatic response to interrupt, and I let him do so. And I let him do so to describe what the background is that he wanted me to hear. In other words, let him have his right of allocution. What ended up being clear, though, is that Mr. Phillips, by page 17 of that transcript, started saying things, which is exactly what the prosecutor articulated in his response to the motion. What Mr. Phillips was upset about was in the amount of a sentence. He was upset about the time period. 9 years is way too much for this. I'm not a drug dealer. I would have fought it, man. That's an unbelievable amount of time. Again, referring to the sentence. I bring these things up because, again, it relates to the fact that it was a voluntary plea. It was a knowing plea. The only problem that Mr. Phillips had was that he didn't agree with ultimately what the sentencing guidelines were or what the court's discretion in sentencing was.
Oh, yeah, she can read the tea leaves. She knows exactly where this is going, and it is not in her client's favor.
And while I told him he's always free to disagree, again, the law is clear that in terms of a knowing or voluntary plea, guidelines are not the issue. So again, I let him continue. He told me at this point that he wanted me to reconsider, and I told him that I wouldn't. He told me ultimately on page 18, after I told him that you told me you possessed with intent to deliver the controlled substance methamphetamine, that's what you told me, and Mr. Phillips answered, I did. And the reason being is because I know I don't have a leg to stand on sitting up here in front of this podium. And I was doing this just to move things along because I know I'm in trouble regardless. Lots of other discussion happened. Lots of other things happened. And Mr. Phillips ultimately said at page 20, don't I have the right to know what my guidelines were before? I didn't. He wasn't there. And I explained to him, again, as I explained in context of this hearing and the last hearing on the motion to withdraw the plea, Mr. Phillips was well aware at the time of the plea he didn't have the right to know his guidelines range. I told him I didn't even know what the guidelines range was at the time of the plea, and I couldn't calculate them until I got the PSI. So he did not have the right to know what his guidelines were before he accepted a plea. That wasn't part of it. And so ultimately, I reconsidered. Ultimately, though it was unusual, I then note that I provided the defendant the opportunity of all of pages 15, 16, and 17 of allocuting, parts of pages 18, 19, 20, 21, and 22. That was all the defendant's opportunity to allocate. And although there was times that I interjected, I let him finish and tell me what he thought. And ultimately, his words had an effect on my ultimate exercise of discretion. I'm not saying that I won't modify sentences if I'm convinced, but I will say that it's infrequent that during a sentencing hearing, a defendant is able to convince me through his allocution to change what is in my mind a fair sentence. But Mr. Phillips did just that. He allocated for the better part of 5 or 6 pages, whatever it was of transcript pages, and I modified the sentence. It was not the modification that Mr. Phillips was seeking, and I told him that, but I ultimately modified my exercise of discretion in the amount of 6 months because I was convinced after hearing from Mr. Phillips, as I have been before, that when he speaks, I generally tend to believe what he's saying in terms of he wants to get away from drugs, he wants to be done being the same person and committing the same types of offenses over and over again. For those things that he said, I generally assigned him a great deal of credibility. I generally believe that he wants to be done being part of this in and out system of going to prison and getting out and going to prison again. So I assigned him credibility in that regard and changed my sentencing discretion, cut 6 months off a sentence, which was not as much as Mr. Phillips wanted, but it clearly demonstrates I was not ignoring what you said, Mr. Phillips. I was listening to what you said. It mattered to me. You had your right of allocution. And so when I look at those things and combine those and I answer the questions put forth in the brief, the motion to withdraw, not to withdraw the plea, the motion to correct an invalid sentence, while it's always the case that Mr. Phillips could have, in hindsight, provided more information, could have provided more letters of support, could have provided more things, ultimately, it's clear that Mr. Phillips knew that he was in this court for a sentencing hearing. He knew that he was going to have to allocate. He was prepared to allocate because he spent a great deal of time doing so. That an attorney now, Ms. Murphy, would second guess trial counsel's strategy is not the question. The question is whether or not I had accurate information when I sentenced Mr. Phillips. None of the other background of the PSI has been challenged. In other words, the fact that I told Mr. Phillips this sentencing is going to be, I lied. I said it was going to be quick because I already know all the background, and then I spent way too much time going over the things that I ended up going over. Ultimately, I was aware of the fact how many felony convictions he had, 14 prior felonies at the time, how many prior misdemeanors he had, 17. I was aware of the nature of the pleas that he entered, that he was entering them voluntarily. I still went probably overboard in going through the reasons why I thought the sentence was appropriate. But the point is, I had all of the information I needed at the time. And that I could have been provided more information is not evidence that I had sentenced Mr. Phillips on inaccurate information. It is perhaps evidence that there was more to supply. But Mr. Phillips was the one who knew he was there for sentencing. He's the one who knowingly and voluntarily decided to plead. I'm not going to fault Mr. Gilo for not providing alternative information because Mr. Gilo was also well aware of the situation of Mr. Phillips. The leg to stand on comment is what I'm referring to. Mr. Phillips, being in a situation where at his relatively young age, at 49 years of age, had 14 prior felonies, knew that it wouldn't necessarily matter to a court how many letters of support they had. Because I have been through this and had the same conversation with Mr. Phillips over and over again. The accurate information was contained within the PSI. I relied upon that and Mr. Phillips' own articulation when I imposed a sentence that was accurate information. It was not inaccurate. And in the alternative, it's not been presented to me in any compelling way that somehow Mr. Gilo was ineffective for not supplying the information that Mr. Phillips didn't even supply to Mr. Gilo. So in sum, it's not my view that there was any invalid information I was relying upon or any inaccurate information I was relying upon. Because it's my view that I was relying upon accurate information. The sentence was and is valid. A valid sentence cannot be corrected. Only an invalid one can.
So long story short, the judge sentenced him to 9 years. And the guy said, 9 years? Well, that's just too much. I don't want to do that much time. And so now he's claiming ineffective counsel. Well, his counsel wasn't ineffective. He just doesn't like his sentence.
So regarding the motion to correct invalid sentence, Mr. Roll, I'd like you to prepare an order that just states for the reasons stated on the record, the court determines that the motion to correct invalid sentence is denied. Can you prepare that order, Mr. Rolla?
And just for clarification, does the court want two separate orders, or do you want me to have it combined in one order?
Does that matter for any way to you, Ms. Murphy? Whether it's
No, it does not, Your Honor. Thank you for asking.
So your preference, Mr. Rolla, just to have it state for the reasons stated. Do you, Ms. Murphy, have any questions regarding the court's order on the motion to correct invalid sentence?
I do not, Your Honor.
All right, I do appreciate the time you've put into this motion, Ms. Murphy and Mr. Rolla, the fact that you issued a response that was helpful, even though it was admittedly late. Mr. Phillips, I understand what you've asserted. I don't agree ultimately with the assertions, but that doesn't change the fact that I still see the possibility that you're going to recover from your addiction issues if you're as serious still as you were at the date of sentencing when you were here before me. I continue to hope that's the case. The court will be in recess on this case today. Thank you.
Judge, may I ask you one question? Do
may.
I need to submit an order for a transcript if after I speak with Mr. Phillips, if he wishes to pursue an application for leave?
I will leave that to your discretion. I'm not sure because I don't know if you're going to need to seek that through the appellate courts or you're going to need to submit it through me. I know that Mr. Phillips was court appointed, so I know that if you take that request, I'll approve it. You're going to need a transcript. I just don't know functionally whether or not that that request is better to the Court of Appeals or better to me. But if it's addressed to me, I'll approve it.
Thank you, Your Honor.
Thank you.
Thank you,
Court is
Mr.
recessed.
Rolla.
Thank you, ma'am.
Thank you, Mr. Phillips. I'll be in touch with you.
All right, thanks. All right, the court is trying to find the rest of our matters. I'm bringing in Mr. Thompson, hopefully to address his matter for this morning if he can get connected. Mr. Thompson, welcome. Are you now connected?
Judge, you'll have to refresh for the Riggs matter to appear on scheduler.
All right, refreshing, and I still didn't see it come up, but I will. Mr. Thompson, are you here now?
I am, thank you.
Okay, then the court calls the matter of People versus Olivia Elaine Eldridge. This is file 22-6435 on page.
For the record, Your Honor, Michael, on behalf of people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Olivia Eldridge.
Thank you. Is Olivia perhaps going by somebody named Livy?
I don't know, but I was told she was calling in, so it might be worth checking.
All right, so I'm going to bring that person is. It's my hope that that's Miss Eldridge. Some brief background is in order while Miss Eldridge is hopefully getting connected. Ma'am, listed as Livy. Are you Olivia Elaine Eldridge?
I am.
Welcome. So some background is in order. Mr. Thompson, I had you in my hearing room for quite some time this morning, but I kept trying to check in and you were not connected via audio or visual. But outside of probably what your knowledge was, I was having difficulty with my audio visual recording system this morning. My docket was so delayed that it was about an hour before I even was able to start recording. So I pushed a lot of matters back. I indicated I was going to push this matter back, but now you're connected. Now Ms. Eldridge is connected. And so I just intend to simply treat it as a jury status conference. But I just wanted to put that background on the record. I had a lot of difficulties this morning. Ms. Eldridge, the question that we're here to first is, have you had enough time to stay in contact with Mr. Thompson regarding the background of this case?
Absolutely not. I haven't spoke to him one time yet.
Why not?
I haven't received anything from him. I didn't even know my lawyer changed.
Well, the question is twofold, so I'm gonna hear from Mr. Thompson on his side, but I first need to hear from you. What have you done to try to reach out to Mr. Thompson?
I didn't know I had a different lawyer. I thought Gary Gilo was still my lawyer.
When did you find out that wasn't the case?
About an hour ago. When I got a message saying I was supposed to be on Zoom with a guy named Jason Thompson.
Mr. Thompson, what say you to that?
I believe when we did the substitution, the normal letters would have been set out, Your Honor. I also would have attempted the phone contact at that time.
Or are you saying that's normally what you would have done, or are you saying that's what you did in this case?
That's what I normally would have done, Your Honor. Yes.
So is it accurate from Ms. Eldridge's standpoint that you have not talked to her?
Correct.
So a little bit more history is in order then. This case is old. I'm not saying this is a negative to the defense or to the prosecution, simply a point of fact. This case was found over on November 8th, 2022. For a long time, Mr. Gilo was the attorney. I don't know how it came up, but all I know is I got a substitution of attorney. It is an order of the court, but I would just tell all of the attorneys, I think what you all recognize is a substitution of attorney is generally always approved. I can't recall ever having not approved. So when I saw a substitution, it definitely did not make a big difference to me. In other words, it didn't mean much to me. It clearly would mean something to the attorney who had to take over. It clearly means something to Ms. Eldridge. But I sign those as a matter of course because it's my view if there's a reason for it, the attorneys will tell me later. So Mr. Thompson, I signed that order on June 7th, 2024, so just about a month ago. Does that sound accurate to you?
Yes.
So you came in very late in this case, given the bind over date. You may or may not know, because you're that new on the case, this matter is set right now for a trial on September 19th. Did you know that?
Yes.
And that was because, as the attorneys now probably both know, there was a law enforcement issue with the coverage of some officers who had to be in a different trial when I originally had this case set on July 16th. So can you give me a little bit of background, Mr. Thompson? Do you know how it came to be that you are substitute counsel now? Did Mr. Gilo stop doing court-appointed cases? What happened?
Yes, I have substituted on a few of Mr. Gilo's cases that are essentially getting ready to be set for trial. With Mr. Gilo's recent health difficulties and things, he has, I don't know if it's every single trial, but cases set for trial are being reassigned, is my understanding.
So independent of the issues that we've heard so far about the length of the case, about the lack of communication between you and Ms. Eldridge, is it fair for me to assume, Mr. Thompson, that you are not yet up to speed on this case?
I am up to speed with the file materials, but not able to speak with Mr. Eldridge.
In your estimation, given that we have a trial in September, that would give you another 2 months and 17 days, September 19th trial date. If you able from this point forward, from today forward, to be in communication with Ms. Eldridge, do you think you could be prepared for a trial on that date?
Yes, I also would ask for Ms. Eldridge's benefit that she have the benefit of an extended plea cutoff, because I would like to discuss that with her.
Absolutely, and you beat me to the punch, but absolutely. I had this set for a plea cutoff, Ms. Eldridge. Were you aware of this?
No, I don't know what that is.
Well, I'll go over it with you now, but to be clear, a plea cutoff just means if you wanted to take advantage of a plea offer, you'd have to do so today. But I'm not going to hold you to that today because Mr. Thompson clearly has just come onto the case. You clearly have not even had an opportunity to talk with him, so he can't possibly give you advice about whether or not it's good to take a plea in this case, right?
Absolutely, thank you.
So I'm going to give you an opportunity to discuss with Mr. Thompson. Let me phrase the question to you, Ms. Eldridge. You know that Mr. Thompson's your attorney now, correct?
Yes, as of right now, yes, I do.
Okay. If I allow you to have sufficient communication with Mr. Thompson from today forward, is it your belief that you'll be ready to have trial if we need it on September 19th?
I am in hope that me and him can work it out and be ready by then, yes.
So what I'm going to do then is I'm going to keep the September 19th trial date on. I'm going to exercise my discretion in extending the plea cutoff. Mr. Rolla, given the circumstances, the people oppose extension of the plea cutoff.
None at all, thank you.
So what I'm going to do is set a hearing. It's going to be in September. September will be the date for that final status conference and plea cutoff. Whatever my motion date is in September, that's what the date will be. Ms. Eldridge, that will give you a period of 2 months to discuss with Mr. Thompson, to review all of the potential plea agreements and decide if you want to accept them. That will be the last date that I'd accept the plea. If, though, you tell me when we get back in September that for some good cause reason, you still haven't had enough time to prepare for trial, I want you to tell me about it. I'm not saying that I necessarily will move trial given the fact that this case is 2 years old, but I want you to bring it up if you think you're not ready for trial at that time. You understand?
Absolutely.
But in the interim, I'm going to expect and require that you get into contact immediately with Mr. Thompson, sit down with him as much and as often as you think you need to fully understand the case, your options and what it means for you, and make sure and cover any potential plea agreements with him in detail. Understood?
Yes.
Mr. Thompson, in light of the court's ruling, Ben, do you have anything further on this case?
Nothing further, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Do you have a good number for Mr. Thompson, Ms. Eldridge?
I do.
Do you have a good number for Ms. Eldridge, Mr. Thompson?
I believe I do now, yes.
Okay, then I'll expect the two of you to get together. We'll see everybody in about 2 months for that final plea cutoff.
Thank you.
Thank you.
Is on the record in the matter of people of the state of Michigan versus Carolyn Suzanne Riggs. This is file number 22-6410FH.
Again, Your Honor, for the record, Michael on behalf of the people.
When Your Honor, Robert Williams appearing for Ms. Riggs, also appearing by Zoom, and I know Mr. Nichols is here also by Zoom. Thank you, sir.
Mr. Nichols, go ahead.
Good morning, Your Honor. Michael Nichols on behalf and with Ms. Riggs, with Mr. Wims for Ms. Riggs by Zoom.
Thank you. And ma'am, for the record, you're Carolyn Riggs, is that right?
Yes, Your Honor.
All right, thank you. So counsel, we're here on one thing. The counsel probably, defense counsel and the prosecutor probably thinks you were here on two, and I'm going to have to clear up why we're here on one and what we're going to be able to accomplish today, because there's a heck of a lot going on. All the way back in this case, before either Mr. Wims or Mr. Nichols were involved in the matter, and perhaps not even Mr. Rolla, I don't recall, the court issued a bind-over order, and that bind-over order indicated several different requirements that are binding upon the attorneys, regardless of whether or not the attorneys changed. That was on 9/26/22. So that was coming up on 2 years ago. Some of the requirements have differences, meaning sometimes later in a case, not in this particular one, I'll set an alternative cutoff for motions, things like that. But in this particular case, one of the things that I indicated was that motions in limine are required for any non-standard evidentiary issue and for any issue requiring a factual hearing prior to a ruling. They shall be filed and heard at least 14 days prior to trial, except for those motions related to Daubert motions, which I had a different 60-day before trial time period. Failure to file such motions or have them heard in accordance with this order will result in such motions being deemed waived. So that was an order of the court in a pretrial order on bind over all the way back in September of 2022. I also would note that throughout a long period of time, this case has been on my docket. And I say that not as a negative for Ms. Riggs or Mr. Nichols or Mr. Wims or Mr. Rolla. My scheduling is difficult because Seafood County is the biggest of 3 counties that I'm a judge in, and it has the most trials scheduled. That complicates not only the motion practice days, the evidentiary hearing days, but I also know that there's been a multitude of motions that have been filed by Mr. Nichols and or Mr. Wims that have all been diligently researched by me, addressed by me, and ruled upon. For example, there was an objection to a 404B notice, which I granted. I did not allow the prosecutor to bring in prior evidence, prior bad acts evidence. There was a motion that the defense filed asking me to dismiss the case on the basis of problems with the laboratory. I had a relatively lengthy examination of the lab technician and personnel. After that evidentiary hearing, I issued detailed findings of fact and issued a ruling as a matter of law that the lab tests were going to be admissible at trial and that Mr. Jeffrey something was qualified as an expert. The attorneys are familiar with the names of the witnesses. The point is, for many months, I've had docket time, docket space, ability, and willingness to cover a multitude of complicated motions. That's why it's particularly problematic for me now, as we are on literally the week before eve of a 4-day criminal jury trial. It is problematic for me to receive one and have reference to motions in limine that are not in line with my September of 2022 scheduling order. They're not within compliance with general practice and expectations of this court, and what I would expect and hope Mr. Wims and Mr. Nichols and Mr. Rolla would all agree with this simple fundamental fairness. And that is, I tell attorneys often, and I believe I told these 3 attorneys in this case, the last thing that I want to have is anyone to be surprised about what evidence comes in. I want the attorneys to be able to know what's coming in because they've properly tailored and gotten the matter ready for trial. And then the argument and the focus of the jury will be, which evidence do they believe? What does it mean? And does it meet the elemental burden of the prosecutor proving guilt beyond a reasonable doubt? That's what trials in our system are supposed to be. Everything should be prepped well in advance. But alas, they have not been prepped well in advance in this case. At our final status conference and plea cutoff, by way of example, Mr. Nichols, you brought up the issue of whether or not there was going to be agreement by the prosecutor to redaction of a testing result to remove a reference to THC, COOH, metabolite of marijuana. And I told you I had not been presented with and therefore did not rule upon it. If you have a motion, you better get filed immediately. I did not expressly tell you that I was going to consider it or not, because I wanted to look back at the court file and determine whether or not I should or would. But you got that motion in limine filed. Confusing to me, so that was the defendant's motion in limine to exclude MSP, THC, COOH metabolite analysis. I got that motion. I reviewed it in detail. I took time out of my otherwise busy schedule to try to be ready to address it. Confusingly, the notice of hearing that was attached to that also referenced that there was a motion for a site visit that was going to be filed by your co-counsel, Mr. Wims. I didn't ever get that. I double checked with my staff multiple times to find out if my staff ever got it. They didn't. I went above and beyond the requirements that I have, trying to find out why I haven't even received it. And to this very moment, I still have not ever received any motion for a site visit. I then received this morning the people's response to the motion in limine to exclude the THC, COOH. I received the people's response this morning to the defendant's 2.513 JLJ motion for site visit. Again, had not received even the motion itself. I took time out of what was already a backlog morning to go through the court file. And of course, because the prosecutor filed a response, it stands to reason that Mr. Wims did file the motion for site visit. It was filed. It just wasn't filed appropriately. And it wasn't filed in accordance with the Michigan court rules, which is to say it's filed and then a judge's copy is sent to me. And more explicitly, a judge's copy is sent to me at my office, which is my primary office in Grayling. So I have not had an adequate time to go over the request at all. This, despite the fact that I put docket time on for today to potentially address these things. This, despite the fact that though this case is 2 years old, it has had all of that time to address these matters. Now the attorneys are telling me we need to address them now within a period of 6 days before the start of a 4-day death case. To say that that's disappointing to me doesn't capture it.
Ooh, I can understand why the judge is a little bit peeved. He sets specific dates. You're supposed to have your motions in by then. And the attorneys just do whatever they want. Yeah, that not a good combination.
Because that's not my view of how things should go. I understand that as attorneys get closer to trials that they know are going to go, disagreements can arise. I try to be understanding of the fact that sometimes things are missed. But that's not how I think law should be practiced in this county or in the state. Complicating all of that background and the way that it disappoints me as a trial judge is the fact that then, while I'm on break from a different case, that I needed to delay for other reasons, I received an email from my staff, a forwarded email from Mr. Nichols, which for the first time is bringing yet another potential massive evidentiary issue into the proverbial mix. And that is a citation to a case, which of course I have not had a chance to review, which apparently was released on June 22nd, 2024, 10 days ago, and which now defense apparently is claiming has a direct impact on how or if certain people can provide testimony. Of course, in light of the timing of that, I haven't had a chance to even look up the case site. I, of course, haven't studied it. It was just released. And so even to the extent I accepted what would be a reasonable argument by Mr. Nichols or Mr. Wims or Mr. Rolla, that the court might be willing to consider the timing of the notification to the court because that United States Supreme Court case was just released. While I can even understand that, it still is problematic. I still have a looming trial date starting on Monday. I have evidentiary issues which the attorneys are telling me need to be resolved and insufficient docket time to resolve them, when all but one of these issues at least could have been resolved years ago. So frankly, other than expressing my reticence and my frustration, I don't know what to do. And I often know exactly what I want to do. So I'm going to invite comment from the attorneys, and then I'm going to decide what to do and when to do it, if I'm to do anything at all with any of these late filings. So I'm going to start with the prosecution, Mr. Rolla. First, I'm going to ask this background question of each of the attorneys. A, did I get the background right? B, do you want to add anything to the background? And then C, what are you asking to do and why? So A, did I get the background right, Mr. Rolla?
Yes,
Mr.
sir.
Nichols, I'll come to you. We're going to go in order on this. I'll get to you for sure. Mr. Rolla, did I get the background right?
To my knowledge, yes, Your Honor.
Is there anything you would have added to the background?
The only thing I would have added is in regards to this case that apparently Mr. Nichols has filed. I have no idea what the court's referencing to.
All right, neither do I. I just received an email that was forwarded from my staff. My assumption in all matters is that if counsel sent something to my staff, they would have copied it to all other attorneys. We'll get to that when I hear from Mr. Nichols, but did you have anything else in terms of the background that you wanted to add before I asked you what you're asking me to do and why?
No, Your Honor, that was the only other addition. Thank you.
What are you asking me to do today?
Judge, again, this is a unique situation that it's the reversal of a position the prosecution's been in, where the court has specifically precluded the prosecution from filing what is deemed late filed motions because they're in violation of a court scheduling order. I think the court has the authority to do that. Obviously, that's within the court's discretion.
Mr. Wims, what should I, well, first in reverse order, did I get the history right regarding this case?
No, I would generally, certainly, of course, you would never intentionally be inaccurate. You're a judge like.
Did you have something additional to add regarding history that I omitted?
Yeah, I'm shocked to hear, of course, not disputing what's on your docket, but I'm shocked to hear that there was no judge's copy because I'm almost certain one was sent out of our motion. And so but I'm sitting here on Zoom, so I can't go check and verify. So I'll just tell you that right now, because as you know, we've sent you judges' copies and all the other stuff we filed. So if it didn't happen, true, it was inadvertent, but it could be some other thing happened that had nothing to do with my office or even your office for that matter. I'll just tell you that. As it relates to the, and then I'll address two things. What I'd like you to do, that apparently you have it now. It's not a complex motion, a site visit motion. I mean, that's not a big ask. Again, it's your court, Your Honor, I get it. But that's not a complex one, and I would hope that you would make time to make a ruling, or that's, again, I'm reluctant to push anything. I sense the court's demeanor right now. I mean, it's obvious. And I'm disappointed that we've disappointed you. And then the other thing I would just tell you about Mr. Nichols, because I'm part of that same email that had the case. It's in response to the 9 p.m. filing we got from Mr. Rolla, where he's suggesting some rather unique evidentiary issues. You probably didn't read it, so I'm not even going to bother your time right now. And of course, that's where that case comes from, that I think it's Arizona versus Smith.
Oh, this guy is bold. Let's see how this plays out for him.
That you have at the U.S. Supreme Court case. but I'm going to guess you didn't look at Mr. Rolla's response, in which case I'm not going to take up any more time on it.
Well, that's maybe a fair guess, but it's inaccurate. I received the response this morning, and because of my issues with my recording system, I had a chance to review the prosecutor's response. I reviewed your motion in detail, and so I was, again, at least aware of what you're claiming and why you're claiming that there's no relevance to the THC COOH. I still have no idea what the case is that was provided because I haven't looked at it. I don't know what it's attempting to rebut or retort. I have no idea what any of that is.
Well, I'll fill you in. First of all, Mr. Nichols handling the metabolite one. I'm doing the site visit one, but the metabolite, Mr. Rolla was on that email. So if you staff got it, Mr. Rolla got it, unless he's having email problems. For what it's worth, we all got it at the same time. But it's in response to the 9 p.m. filing.
Well, let me hear then from you, Mr. Nichols. Is it accurate you're handling the motion, the response to the THC COOH, and Mr. Wims is handling the motion for the site visit?
Yes.
Let me go backwards then. Did you have anything that you think I missed or omitted from the background of this case as it relates to anything I've said so far or anything you wanted to add?
Yes.
Okay.
If I may, by way of an offer of proof, my offer of proof is that neither I nor Mr. Wims have received curriculum vitae, summary of expert testimony, even designation of an expert witness, which is a violation of the court's order because it violates MCR 6.201. Now, the response that I received somewhere after 9 o'clock last night talked at paragraph 5. It was a motion to admit evidences. That's at least the way I took it from Mr. Rolla, who was on the email earlier this morning, talking about a couple of things that really concerned me because he's never given us any notice, any summary, not even a vita for the medical examiner, but talking about wanting to use the medical examiner to put in the post-mortem blood analysis for Mr. Runser. And the way I took it, again, this is paragraph 5 of what he filed at about 9 o'clock last night. The way I took it is he wants to use that testimony from the medical examiner, who I don't believe would have done the blood analysis. And he wants to use that to compare Mr. Runser's THC level at the time of death with Ms. Riggs' THC level at the time of death, ostensibly because it's higher, which not only offends the longstanding SCOTUS, Supreme Court of the United States, doctrine of confrontation as interpreted by Bullcoming, but the Supreme Court had a almost on point scenario when it released the Smith versus Arizona case about a week and a half ago. So I was concerned about Mr. Rolla trying to do that, offending, not just the rules of evidence, Your Honor, but the Constitution, the confrontation clause of the Constitution, which I think trumps, everything. And then the other issue that he raised was a motion. Again, I'm calling it a motion to admit evidence, but he's telling us at paragraph 5 that he wants to use Jeff French to testify about how marijuana works in the body and how it affects people and how it can be intoxicating, which would offend rules of evidence 702 and 703 and would be inconsistent with what Mr. French testified to you last fall at pages 101 and 102 of his testimony. He essentially said, all we can say at the Michigan State Police lab is whether or not there's marijuana in somebody's system or not. We don't testify that it can impair a person, that it did impair a person. We don't know that. Of course they don't. And there will be no testimony in this trial upon which Mr. French could give any expert opinion at all. I mean, they've got her statement that she used her medical marijuana at about 6:30, and they've got the driving. That's essentially their evidence. So that's why I sent that email with Smith versus Arizona, because I figured let's talk about it now, even if it gets under your skin a little bit, Your Honor, because it's better to talk about it now than have it come up in the middle of the trial and we got a jury waiting for 2 hours while we're fighting it out over whether or not the medical examiner can testify about some test that somebody else did from an autopsy report, ostensibly a portion of an autopsy report for Mr. Runser. So that's my concern. I'm pretty surprised and disappointed myself that we don't have a CV or an expert summary. We don't have compliance with the court rules. And I get this motion to admit evidence in the form of a response at paragraph 5 last night at 9 o'clock.
Okay, so really quickly, I just want to give a minor recap. So there was a motor vehicle accident, her and a guy. The guy passed away. Both of them had THC in their system. Her attorney is trying to get the records of her THC level thrown out, saying it's irrelevant because the man who passed away, his THC level was higher than hers was at the time of his death. So, and the Supreme Court ruled on a case almost identical to that, apparently, a week and a half ago. And so they have a solid ruling to compare it to.
Of course, going to proceed. I'm going to start with the motion regarding the site visit. And the court would indicate that, as was articulated more clearly by Mr. Wims when I let him be heard, you're accurate, Mr. Wims. The motion for a site visit is not particularly complex. It is arguably time barred because it's a motion in limine, although, again, it's clear to me that within my discretion, even after the jury begins the deliberations, if there was a request by the jury, I would be within my discretion. I would have the opportunity to decide whether or not to grant it. So arguably, no pretrial motion is ever needed for something like a site visit. On the other hand, you have known for 2 years, or at least as long as you have been on this case, the exact site or close to the exact site of the accident in question. And therefore, you could have made the request long ago. To me, there isn't any basis to fail to do that. Outside of timeliness issue, though, I tend to agree with you. It's a fairly straightforward motion. The court is going to be treating this part of the motion as if it were timely filed, as if I timely got it, and as if it were otherwise ready to be addressed by the court. And so I'm going to address it. I'm going to address it in the context of and with the benefit of CR 2.1193, and I'm going to dispense with oral argument. I'm not in need of it, because ultimately, a lot of my determination in this case, as it relates to the view by the jury, is what happens at trial. And that's because the court notes the statute at issue 768.28 does allow the court may order a view by any jury and panel to try a criminal case, whatever the court shall deem such view necessary. Lots of cases have interpreted that. Lots of them were cited in a brief that I was finally able to read this morning. It should be done, however, a site view only where it's uncertain whether the jury has been able to visualize the surroundings from the testimony. And it's up to me, the trial judge, to decide whether to grant a defendant's motion for a jury view. Again, numerous cases have upheld that same general principle, which is what Mr. Wims has indicated in his motion. It's up to the court. It's within my discretion. Trial courts don't abuse their discretion in permitting the jury view of crime scene, even though lighting and other conditions are not identical. If jurors were fully apprised of those differences and the view helped jurors to better understand the distances involved in the way evidence admitted in trial, especially the credibility of eyewitnesses. That was the Mallory case, which I believe was directly cited by Mr. Wims in his motion. But a jury may not view the scene of an accident resulting in death in order to augment evidence introduced on the trial. A view is only for the purpose of making clear in the minds of the jury the evidence already introduced. So in light of that controlling principle and my discretionary authority, the court holds in abeyance any determination on a view by the jury. If the defense renews its request during the jury trial, I'll make my determination in light of that and other case law, and I'll consider, in my view, after I've heard all of the evidence, whether or not the jury will be aided by a site view. Those are the legal implications that I'll take into account. Those legal implications are only part of my inquiry and my determination, however, and so I'm going to enlighten the parties about what other things I'm going to consider and what they should be prepared to help me unpack if I'm going to consider a jury view from a legal implication standpoint. That is there a significant difference between lighting and weather conditions? Does it matter? And I instruct the jury in that way. And is the jury going to likely have augmented evidence introduced on the trial, or is the view only for the purpose of making clear in the minds of the jury the evidence that's already been introduced? To the extent the court finds, for example, later that the testimony of witnesses does not necessarily contradict or is clearer that it paints a good picture for the court and the jury, I may deny the jury request or the request for jury visit if I find that it otherwise would help the jury to visualize the surroundings from the testimony that's provided. But I'll take that all into account after testimony and evidence is in and after some further supplementary argument by the attorneys. I'm also going to take into account other things that I must do as a trial court judge, which include the practical implications, from any decision by me. That includes things like transportation, how and whether I can accomplish that on court, at court expense, and with court oversight, because the attorneys well know that the requirement is if I do take the jury to view a scene, I must do so under court oversight. The practical implications of that are not insignificant. With a jury that I expect to seat 14 individuals, taking 14 individuals to a site visit with the view and benefit of, as I need to, as my understanding is, Ms. Riggs, Mr. Wims, Mr. Nichols, Mr. Rolla, perhaps the primary officer investigating the case in Mr. Rolla's police witnesses, myself. That is a lot of people to get to a location, which at least as presented from the vague facts that I know, the attorneys know them better, is a dangerous area where a fatal accident happened. It's also the other potential impact of conduct of jurors and what the court can do or should do to accommodate whatever conduct might happen. For example, do jurors talk and look at things outside of what the attorneys are suggesting? Is there safety concerns with the jurors? Is there safety concerns with the parties in the court? Can I possibly have a jury view a site visit, and even if I instruct them to only take into account the visual representation of the road, can I possibly stop them from looking at and perhaps relying upon other things that the attorneys don't bring up? Those are all practical implications that the court has a concern about, even if I'm convinced on a legal standpoint or from a legal threshold that it makes sense to have a jury view. So I'm holding the determination ultimately in advance. Mr. Wims, you need to bring it up to me again. If you are still convinced that a site visit would benefit the jury, you'll need to do so after the evidence has been presented, because I fairly expect presentation of scene of the accident from each prosecution's witnesses and defense witnesses. So I'm not going to make a ruling on this until I hear all of the evidence that potentially is going to cover the issue of the site and the visualization and whether or not the jury can visualize it. Then if the defense is still making that request, you'll make it. I'll have the jury excused. I'll hear supplementary argument about the practical and legal implications, and then I'll make a determination in light of all of those things. Mr. Rolla, what I'd like you to do is, I'm considering you the prevailing party. I'm denying for now the evidence, the request for a view by jury, but I'm doing so without prejudice to it being raised in trial. I'd like you to prepare an order that says, for the reasons stated, the court is denying the request for a jury view at the present moment, but will hold in abeyance any further or future, not for any future request by the defense for a jury view, and will then allow supplementary argument and make a determination.
So the judge doesn't want to take them on the field trip. The judge wants the lawyers to do whatever they can to figure it out and not take them on the field trip, because it's too hard to control 14 people plus, the all of the other people from the court that would have to attend, and make sure that they're only taking into view what they're supposed to and not taking other circumstances that aren't allowed to be considered or aren't part of the evidence that's been submitted. What if one of them sees something that, that wasn't brought up, and then that's used to, sway their opinion? Not talking, 14 people having to keep them all keeping their mouths shut. I mean, it's a huge risk.
Can you prepare that order?
Court wants it indicating denying the motion at present. However, the court will allow
the defense to make a subsequent request Then I'll allow supplementary argument and make a determination.
Very good. Thank you.
Moving on to the motion regarding the THC-COH metabolite analysis, the court would indicate that I've had the benefit of both the defendant's motion as well as the prosecutor's response, albeit the prosecutor's response was received by me this morning. Because as I've already stated, I had an opportunity to review that request, the response to the request, I'm ready to rule. And though this is a late filed motion, I have the discretion to consider a late filed motion. And while I've made much of the fact that I don't appreciate having matters filed on the eve of trial, because I think they should have been filed a long time ago, I'm also appreciative of the fact, and you clarified this for me better, Mr. Nichols, that I would rather have it settled before trial, even if it's on this late eve of trial, than during the trial. And so while it's still upsetting to me that I'm deciding evidentiary issues so close to the start of a 4-day trial, I also appreciate the distinction, and you're right. Having it settled before trial is still ultimately better than during trial. I agree with you on that point. I had a chance to review the defendant's motion in limine, and the motion, in essence, is arguing the point of relevance. The court would start by noting that the background or the underlying threshold for relevance is relatively low. As indicated by the people's response, the rule is evidence that has any tendency to make the existence of any fact that is of consequence to the termination of an action more probable or less probable than it would be without the evidence. And so what I would have to make a determination first is that there's probative value to the proposed evidence. And as I understand it, the argument is about whether or not either one of the labs can refer to THC-COOH was a metabolite of marijuana. Metabolite meaning it's not the psychoactive ingredient in marijuana that perhaps, or argued by defense, in any way makes a person intoxicated, but instead is presence of metabolites which show that there was prior use of marijuana. The argument by the defense is that whether or not there's 0 or 1,000, whatever the measurement is, nanograms per milliliter, the metabolite has no relevance to any fact at issue in this case, because the question is whether or not Ms. Riggs was intoxicated, and only active THC can intoxicate an individual. In other words, and also the defense argues that in this case, it was clear Ms. Riggs had admitted to police that she had smoked marijuana in the morning of, or the morning of the day of the accident. And so the defense argument also appears to be that the evidence will already come in. There's no disagreement that Ms. Riggs had marijuana in her system. The question is the effect on her of the marijuana that she did have in her system. So I understand the argument and the prosecutor's counter. There was a citation to the case of People versus Friesel, and the paragraph 5 of the motion says Ms. Riggs seeks to exclude any mention of the inactive THC metabolite during trial under People versus Friesel because it's not relevant. But the court reviewed People versus Friesel, and in my review of that case, People versus Friesel merely held that 11-carboxy-THC is not a Schedule I controlled substance, and therefore a person cannot be prosecuted under MCL 257.6258 for operating with any amount in their system. At least as far as I reviewed People Friesel, and again, I had to do so on an expedited basis given the timing that I've already discussed, the case didn't talk about THC-COOH, the subject of this motion. Although defendant does clarify, at least in its argument in the motion, that it's claiming that they're the same. THC-COOH is the same as 11-carboxy-THC. I assume without deciding that defense's representation in the brief is correct, it's accurate. I say I assume without describing, also while noting that the prosecutor didn't take issue with that representation. But regardless, Friesel just simply held that a person can't be charged for operating with any presence for having a metabolite. That's not answering the question at issue before the court, however, whether or not the presence of a marijuana metabolite has any or bears any relevance to the ultimate question of whether or not Ms. Riggs would have been or was intoxicated by the amount of psychoactive THC in her system. And so while I understand the reliance on Friesel, it's not directly on point to the court. It's not compelling to me in terms of argument. When I look at the further arguments, the argument is that even if there's some minimal or minimalistic relevance to the fact of the THC-COH metabolite, it's also overweighed or outweighed by the danger of unfair prejudice, by needless presentation of cumulative evidence, or by the danger of that, substantially outweighed by the danger of unfair prejudice. Defense also argues that it would confuse the jury. I find it hard to believe that the jury would be confused, number one, in the context of a 403 analysis. And that's because during the context of this long case with these well-experienced attorneys, I've been convinced often by well-weighed arguments how to set aside things that don't matter. I've been able to do that. I think a reasonable juror could be able to do that as well. Meaning, assuming that Mr. Nichols and Mr. Wims are as confident as they are in their brief that the THC COOH is not indicative of intoxication, my assumption is that both of those attorneys, or whoever is cross-examining each state witness, would be able to elicit that testimony from the state witnesses, and would also point out to the jury during argument very cogently, clearly and effectively, that if it is an inactive substance, in other words, if THC COOH does not intoxicate, you should not consider the fact that she had it in her system. In other words, I don't think that it's very likely the jury is going to be confused even if they hear about the fact that there's THC COOH. Again, that's not the only basis that defense offers its motion to exclude, however. It is clear in the court's mind that the presence of a metabolite, THC COOH, in one system is evidence of the use of marijuana. It appears to be clear. Everybody appears to concede that. The more amount, therefore, it would seem to be a reasonable inference, the more amount of THC COOH metabolite would indicate the more use.
If the jury gets confused, I'm sure the judge could clarify it.
So the higher the amount of metabolite, the more amount of use. If so, it's arguable at least that the metabolite could offer some indirect proof of the amount of use. While it could perhaps demonstrate intoxication, which is what the prosecutor must show, it could be some evidence, even if it's indirect evidence of use or amount of use. But again, the court notes that according to the prosecutor's offer of proof and the defense's own offer of proof, the defendant here acknowledged using marijuana. The question then becomes, from an evidentiary threshold, can the prosecutor prove intoxication? And next, does the presence of metabolite, any high amount, low amount, medium amount, or any amount, prove intoxication? That's where the logical link seems to disappear to the court. I understand the relevant evidence threshold and that relevance is a low evidentiary threshold. And I understand that the evidence of a metabolite in one system is evidence of use. But in this case, the defendant admitted using marijuana. The question is whether she's intoxicated. The prosecutor must have proved intoxication, and I'm aware of no cases that demonstrate that THC, COOH, itself in a person's body at A level, B level, C level, or triple X level means that there can be any type of indication of intoxication from it. All of the cases that I have been aware of say opposite, that THC, COOH is an inactive ingredient. It does not demonstrate intoxication. If there is relevance to the THC, COOH, it's relatively minimal then, because what the prosecutor has to prove is intoxication. What the prosecutor has to demonstrate is that the defendant didn't just use marijuana, but she was intoxicated by it. When I consider it in that fashion, and I consider that the evidence of THC, COOH itself cannot, as far as I can tell through any published case that I've read or has been offered to me, show that there's intoxication. And one case, Friesel, although I didn't find it compelling in terms of the defense's argument, said specifically that you can't be convicted of operating with the presence in your system of 11-carboxy-THC. When I combine those two, I don't find that there's overall enough probative value to the evidence of THC, COOH. In other words, there is a danger of unfair prejudice. And even though I don't believe that the attorneys would suffer due to confusion or the jury would be confused, there's a potential of unfair prejudice because what would happen is the jury would be able to hang its hat on a number that has nothing to do with the ultimate question in this case, intoxication. Doing so, allowing the jury to do so, to have admitted a lab report that contains a number that has nothing to do with about intoxication, is what leads me to conclude that there's a substantial chance that there would be unfair prejudice. In other words, due to the low probative nature of the value of the evidence and the low probative value, it is substantially outweighed by the danger of unfair prejudice, not confusion of the issues. As a result, and because I'm not convinced that THC COOH bears any real relevance to whether or not Ms. Briggs was intoxicated, it's not able to be shown to the jury. And I'm going to order that there is no reference to the amount of that substance in Ms. Briggs' system. I'm not making any specific ruling on any other point. I am ruling that the lab shall be instructed and any witnesses from the police shall be instructed that what is relevant is the amount of active THC in Mrs. Briggs' system. Of course, it will be admissible for the police to testify, according to what even the defense has stipulated, that Ms. Briggs acknowledged smoking marijuana the morning of the accident in question, but the prosecutor still bears the burden of proof of demonstrating intoxication. So the evidence regarding the active THC can come in, the evidence regarding the metabolite cannot, for the reasons I've stated. And the witnesses shall be instructed in that way as well. Mr. Rolla, do you have questions regarding the court's order?
I do, Judge. One specific, the court's already ruled after the Daubert hearing as to the admissibility of a lab report, specifically as to the tests. On that lab report, it referenced the COOH THC. Is the court going to then amend its prior order, or how do you want to have that handled?
Only to this extent. The challenge to the report was whole. In other words, at the evidentiary hearing, the challenge was to the underlying testing protocols and whether or not there was accurate and reliable testing, to which I found there was. The challenge at that time was not to the specifics of the testing. It was to the specifics of the testing result, but about whether or not it was reliable in light of the problems that were identified with the lab testing. So I am amending the prior order, but only to the extent that it was still reliable testing. There's been no question and been no argument that somehow Ms. Briggs's amount of THC COH is wrong. It's only an argument that it's not relevant, or that if it is relevant, it's substantially overweighed or outweighed by the danger of unfair prejudice. And so I'm amending the prior order only to the extent that I'm directing that evidence of the THC COH is not admissible at trial. The methodology, it was not, again, it's not been shown to me to be improper. It's just simply that there's no relevance to it, not that it was erroneous or it should be, deemed inadmissible due to errors in the lab testing protocol. Do you have any additional questions?
In that regard, Judge, then we do actually have, and it's been provided some time ago now to defense counsel, what is actually the same lab report, but now number 4, which only referenced the Delta 9 THC. And that's why I asked the court the question I did, because in regards to presentation of evidence, although we've listed lab reports 1, 2, 3, and 4 as exhibits, it would make a difference on what evidence the people would then be presenting. That's why I inquired of the court. And one.
Yeah, so
go ahead.
So it doesn't matter to me. It doesn't matter how the evidence comes in, so long as when the lab reports come in and the testimony is offered, there's not discussion, evidence, or otherwise about THC COOH. So the 9-carboxy THC, the active THC, is absolutely admissible. That wasn't the target of the motion by defense. So if you admit 2 different possibilities, if you have a lab report, as you just stated, that only contains the 9-carboxy THC, that's admissible, assuming you lay foundation for it. But if you have the lab report otherwise that also listed 11 of the THC COOH, you can simply redact it. That's another option.
And also, thank you. I would indicate for the record, it was at actually 10:38 this morning that our office did receive Mr. Nichols' email. So I do see it there. I do see the reference to the case, which apparently is 22 pages long with 22 additional pages of concurring opinions. So I haven't had a time to review the Arizona case. Thank you, Judge.
Well, that's fine. And I'm not ruling upon that. That's not before me. And although I have a strong preference, as the attorneys have heard repeatedly today, to have things decided before, I'm not going to make a decision about something I know nothing about. The attorneys are going to be prepared to argue it, and you'll enlighten me, and then I'll rule upon it if there's a disagreement at trial. Mr. Nichols, because that was your motion, I want you to prepare an order which just states, for the reasons stated on the record, the court grants the motion in limine. It will specifically exclude from trial and evidence any testimony regarding THC, COH, and any lab report indicating the presence of THC, COH for the reasons stated. Can you prepare that order?
Okay,
Do you have a question regarding that order?
I do not.
Mr. Rolla, I'm going to start with you and then go ABC through the attorneys. Is there anything else I should be aware of, even if I'm not going to rule upon it right now, as we anticipate and get ready for trial?
Not from the people, thank you, Your Honor.
Mr. Williams?
Yes, Your Honor, you asked us your order to file experts and all that, witnesses 14 days ahead of time. We did that. I got the prosecutors yesterday afternoon, 7 days ahead of time. And Mr. Nichols mentioned it also when he was discussing with you. We have never gotten CVs, descriptions of testimony. There's there's something here about diagrams and autopsy photos, nothing that's ever been provided to us. There's no, I don't even know, there's no accident report. I don't even know what they're talking about here. And I would just say it's a little difficult with a national holiday and weekend. We're 6 days out of trial. We don't have the evidence and the stuff we're supposed to have. There's no expert designations. And I would just say that, you know, if you remember, of course, it was when I got into this case, we tried to have it remanded for a prelim. We got fought tooth and nail. A lot of that would have shaken out at a prelim. I would just ask that the court would hold the prosecution to your court order, not a suggestion, but a mandate. And that these things, whatever he tries to eventually actually bring into evidence, like I said, there's been no experts, no CVs, no indications of testimony, no accident reports, none of those things, that they will, of course, be kept from the jury, and that this is not, I mean, these would be huge, big deals for us to try to scramble and get ready for, even if they were somehow granted to us sometime today or tomorrow.
I'll be sure to take note of those arguments when you raise them at trial. I'm not going to address them now. When and if they come up, I'll make an appropriate ruling after I hear argument from the attorneys.
Thank you, sir.
Mr. Nichols,
Thank you for hearing. And thank you for, I'm sure Mr. Roll would say the same thing, for hearing the substance of our motions this morning. Appreciate you scrambling like that. None of us, I'm sure, wanted to put you in that position.
Mr. Nichols, anything further you'd want to bring me up to speed on?
Smith versus Arizona came out the same day as that famous gun case, Diaz, from the Supreme Court. And of course, that case got all the smoke. So I'm not surprised that Smith versus Arizona went under the radar. That's all.
I'll make sure and review that case, as I'm sure the attorneys will. Prepare your legal arguments. I'll make the legal rulings once they're before me. If at times we need to excuse the jury, I'll be mindful of that. The attorneys know we only have what time we have. I have read the list of witnesses. I'll be going through in detail all the jury instructions this week. But you know, each of you, how many witnesses we're going to have. I expect we're going to have some difficulty perhaps getting through a trial, even though we have 4 days set aside with the amount of witnesses if they all get called. So I need you all to bear that in mind as well. I certainly will. We'll see you at 8:30 in the morning next Monday.
Thank you.
All right, Mr. Kearns, I know you're on the road, so do we have Jordan Burgess with us?
All right, guys, you lived through that. I am sorry to those who didn't like that. I found them very fascinating. So we're just, you know, we're going to have to do that once in a while. On the bright side, new voice. And this is another one of those where this is going to be a mystery. I threw it on to the end. I did a real quick edit. I don't know what's in this. I love you.
I believe we have him available by Zoom, Your Honor.
There he is. What are we doing in Mr. Burgess's cases?
Your Honor, I know that we haven't made a lot of progress on these since they were initially filed. We were working toward a global resolution potentially on these. However, I was referred to new charges on Mr. Burgess, I think on June 17th. They are felony charges. I think it would be counterproductive for us to do anything on these matters until that case is filed. Mr. Kearns can make decisions on whether or not he wants to pursue a global resolution in light of those new cases, but obviously I wouldn't put him in a position to make any kind of decision on that until he's had an opportunity to review the discovery in those as well.
Mr. Kearns.
Your Honor, I'd concur with my colleague. I'd like to see what's coming down the pike so I can make an informed decision and recommendation. If we could get a status conference sometime after I learn what these new charges involve and what the evidence is, that would be helpful to a resolution.
Okay, Mr. Cunningham, have you filed the new charges?
I've not, Your Honor. As I said, they came over in the referral just before I went to camp, and then I had trial last week. My goal is to have them done by Friday.
Well, if I'd set this out for August 13th or August 27th, would that be sufficient time to at least kind of figure out where you're at?
I certainly can have the affidavit and complaint to Mr. Kearns. I don't know that we'll have the full orb discovery by then, but I would think we would, since these were long formed and referred over from PD. We should have all the reports for the most part.
Mr. Kearns, the 13th or 27th of August, which do you prefer?
Can I have the 27th, please, Your Honor?
At 11:30, well, we're going all 11 o'clock. I mean, if you're on a little later, you're on a little later, because we've got a number of out-of-town attorneys we use our last link for. So we started opening it up at 11 o'clock. So it'll be set at 11, but just let the court know if it's going to be a little later in the hearing that you're going to be on.
Thank you, Your Honor.
So August 27th at 11 is when we'll set the status in those three cases. And then I assume we'll do a first appearance before, so that the newest cases to you also.
Yes, sir.
Thank you, Your Honor.
Okay. Anything else with Mr. Burgess?
Not at this time. Mr. Kearns, will you waive signature on the journal entry?
I will.
Thank
Thank you.
Mr. Kearns, anything else for you?
No, Your Honor, thank you.
You're excused. All right, Mr. Rohr, you have Greg Gordon.
Yes, Your Honor.
Mr. Gordon with us today?
Kansas.
I believe so, Your Honor.
Mr. Gordon, audio and video?
Yes, sir.
All right. Counsel, Mr. Rohr, and guess this is Mr. Cunningham's.
It's mine, evidently, Your Honor. Sorry.
Forward in this matter.
Your Honor, we've had plea negotiating back and forth. I think at this point we can just set it for a preliminary hearing just to keep the case moving along.
How long do we need for preliminary hearing?
I don't think more than an hour.
I would agree, Your Honor.
Okay. We'll get it scheduled for prelim. Anything else with Mr. Gordon?
Not from the defense, Your Honor.
Okay, he's excused. And then how about Cassius Russell?
Yes, Your Honor. That's with Mr. Rutherford. We've had some, Mr. Russell has a case in Russell. So we are trying to work a resolution to resolve the Ellis County matter so he can go to Russell and face that pending revocation that he has there.
Is he in the Ellis County Jail?
Yes, Your Honor.
Okay, that's you right there, Mr. Rook. I didn't recognize you. So do I need to set it out for another case or another hearing, or what are we doing?
I think we'll have it resolved probably through a misdemeanor plea so that he can be released to Russell County. I have to verify some information with Russell County before then. So we might want to set it out a couple weeks, but we might not need it.
July 30th at 11, Mr. Rohr, does that work for you?
Yeah, by Zoom, we'll make it work.
Yep, it'll be a Zoom. And if it's resolved prior to that time, we won't need a hearing on the 30th.
Yes, Your Honor.
All right. Anything else for Mr. Russell?
Not for me, Your Honor.
Mr. Rohr, would you waive signature on the journal entry?
Yes, sir.
Thank you.
He is excused. And Mr. Rohr, you're excused if that's all you have.
Your Honor, I believe do we have a Sean Wallace today too, or no?
Yep, we do.
Bring him in.
What's that?
Yeah, he's in here now.
Mr. Wallace, audio and video, please. Mr. Wallace, you're not dressed appropriately. Hold it. He's not dressed appropriately. Get him off the video. He needs to put a shirt on that's decent, and then we'll bring him back.
Yes, Your Honor.
All right. Let me see if I'm at work. Let me see if I can find a shirt.
Emily, get him off the video. Okay, we'll take up Mr. Stevens' case next.
Yeah, we can do that, and I'll send her an email, see if she's paid or not.
And who does he need? Kristen Baxter?
Kristen Baxter, yeah.
So that reinstatement was.
Ms. Baxter, audio and video? Well, we'll wait on Ms. Baxter, Mr. Coombs, and Mr. King. What are we doing in Mr. King's case?
Your Honor, I think we have got some plea negotiations figured out, and I will be getting back with Mr. Cunningham on that. We'd like to set up another status just because to keep it moving, but I believe we can get this case resolved here shortly.
Who's on the other side of that? Mr. Cunningham?
I am, Your Honor, yes.
August 13th at 11.
That will work for me.
And if it's resolved before then, we won't have a hearing.
Sounds good, Your Honor.
All right.
Mr. Coombs, do you need, or would you waive signature on the journal entry?
Yes, I will waive signature.
Perfect. Thank you.
Mr. King, you're excused.
Thank you.
Now, let's see if Ms. Baxter is back.
I'm here.
I need to see your audio, please.
Your Honor, that's my only case, so may I be excused as well?
You're excused. There we go. There's Ms. Baxter. Mr. Stevens,
Yes, Your Honor.
how are we proceeding in Ms. Baxter's case?
Your Honor, at this point, my notes indicate that there are a few things that I would like to check on. There has been an offer extended by the county attorney. I believe that we are close to taking that offer, but there are a few things that need to be double checked before we accept that offer. If we could set it for status with the understanding that if an offer reached, the status would be unnecessary and we could set it for a plea or something else.
Okay. July 30th at 11, you think?
Let me just check real quick. I am scheduled to be in your court at that time anyway, so that will work for me, Your Honor.
Okay. July 30th at 11, unless it's resolved prior to that time.
Thank you, Your Honor.
All right, thank you.
Will you waive signature, Mr. Stevens?
I will.
Thank you.
I believe that's my only case, maybe dismissed.
You're excused, Ms. Baxter, you're excused.
Thank you.
Mr. Wallace ready to come back? All right, Mr. Wallace is back. How are we moving forward in this matter, counsel?
Defer to defense counsel, Your Honor.
Mr. Roy, you're on mute.
All right, sorry about that, Your Honor.
No problem. What are we doing in Mr. Wallace's case?
I have Mr. Cunningham and I exchanged emails this morning. We have a plea offer from the state. I think at this point, we could set it for prelim, and if we're able to work it out between then and now, that's fine. But I think just to move it along, that's what I would ask. I don't think prelim shouldn't last more than an hour, Your Honor.
Mr. Cunningham, an hour sufficient?
Yes, Your Honor.
All right, we'll schedule it for prelim. Mr. Wallace, maintain contact with Mr. Rohr. He will let you know when your next hearing is scheduled.
All right, appreciate it. Thank
All
you.
right, you're excused.
All right, thank you, Judge.
Yep, you're excused.
Thanks, Mr. Cunningham.
Thank you.
And I still have on Timothy Handlin with an attorney by the name of Rex Lorson.
Yes, Your Honor, I show that as well. And then I also show Daniel Rhea on with Richard Beckman.
Mr. Beckman called Sandy this morning and he's on his way back from Wisconsin.
Oh.
So he asked her if she could move the hearing.
Okay.
So.
I will forgive him even though he butchered Wisconsin.
You have Tim Handlin right here.
Do we have his attorney?
No.
Unfortunately, he said he was in trial today. Can you hear me okay?
Yeah, I can. Well, I guess, Mr. Cunningham, what do you want to do with it? Move it down a couple of weeks?
Yeah, we haven't spoken since this has been filed in district court, so I'd like an opportunity to discuss it with him and see how he wants to move forward.
Well, Mr. Handlin, we'll move it to July 16th at 11.
Okay. What is this?
We're going to set it for another status so that Mr. Cunningham and your attorney at least have a chance to speak.
Okay. So the 16th at what time?
11 o'clock.
11 o'clock. I will let him know. I'm sure you will too.
Yes. All right, that's all I have.
Oh, that was so much fun. I love those wild rides with you guys. You guys keep me laughing all night long. Seriously. I was worried though with the one case. I I really was worried. I was prepared to skip through the last two. I was like, oh my gosh, they hate it. They hate it. I know the judge droned on and on and on. But they were so fascinating. Hi, Global Girl. I'm so happy to see you. How long have you been here, my love? All right, guys. We had the whole paw firm on screen tonight. They all wanted their extra treats. I took the limitation of the treats off the table today. I'm sure it wouldn't matter what I played, Jill would find a way to stay entertained. Oh. But yep. I'm gonna go over to the Discord for a little bit. So you guys are absolutely welcome to join. We had the link up for quite a while, so it shouldn't be hard to find. I don't have it handy right this moment, but I'm sure one of my amazing mods is gonna throw it up on the screen. And then you guys can come in and play games or sit and chat and talk about the cases. And it was a really great night. I absolutely love you guys so much. You make every day worth it. And I'm going to have to figure out something really great for tonight, being the 4th of July. Auntie M said that she has some great ideas, and I'm all for it. Yeah. That's pretty much it. Yeah. It worked though. It worked. They came up and got on screen. All of them did. When I took Ava out, I had to lock Billy and Earl both in the bathroom because I'm not risking it. I'm not. Nope. When Billy came home, he was wet because it was raining, and he doesn't really approve of rain. But beyond that, he was just scared out of his wits from the fireworks. Like he started heading down to the basement, like to go hide, and then he jumped up on the railing and like scurried off into the living room where Earl was, and he was just not himself. He's usually such a confident cat, and when he came home, he was just not. He was not okay with himself. So, but I was so happy to have him back. I had to take a can of food outside on a ceramic plate and like tap the sounds together, and he finally came up, but he wouldn't eat. That was the other weird thing. Like he would not eat. Ava ate it. I put it behind the dog gate, but I didn't secure the dog gate with the vacuum cleaner like I normally do. And Ava wedged herself behind the dog gate, pried it open, and got to the food. And then I came in my bedroom, and she had gotten in my garbage can while I was out looking for Billy. She got in my garbage can and pulled out a wrapper and some Q-tips and the licky treats tubes, the empty tubes, and of course shredded it all under my chair area. So yeah, It was great. It was great. I was so happy to walk into that. Oh, I love you, Nana Laura, honey. Do you know how often that happens? Yep. That's one of the things I love about our chats is everybody's able to find someone with similar circumstances going on. And because we're such a close-knit community and family, we help each other through things and we're able to learn from each other. I can't tell you how many times I have learned from y'all's conversations. And I appreciate it. I really do. I love that we're always there to help each other. And you guys have given me some amazing advice. Sometimes when I've needed it the most. So you never know. You never know who you're going to meet and what you're going to need until it's there. So that's why I say entire communities change one person at a time. And we are here to make it better for everyone. 100%. We really have the best people in the world. Your job is to make me laugh, and you do that plenty, big butthead. They are. They're quite cool. They are quite cool. I have to check my email, sweetie. But we tested last night, and we think we've got it figured out. That we have a way that we're pretty sure is going to work to get merch to international subscribers. So we are in the process of making 100% sure, but we're pretty sure it works. Okay, I will get back to you in the email for sure, love, and I'll help you understand. We got tricks. We got tricks around here. Yes, me too. I can't wait to see you in it. Oh my gosh. I can't wait. I'm so excited. All right, guys. Be safe, be well, sleep sweet, and much love.